Test. It's a test of the ceremonial courtroom for YouTube.
state of the United States and this honorable court.
Good morning, ladies and gentlemen. Our first case for argument this morning is CBOE Exchange against the Securities and Exchange Commission. Mr. Dunbar.
May it please the court, Kelly Dunbar for CBOE Exchange. The SEC order should be vacated for two principal reasons. First, the SEC applied the wrong legal test in determining the scope of its statutory power under the Exchange Act. The statute and the SEC regulations tie exchange status to functionality, not corporate affiliation. And under a functional test, Silex, the software product at issue here, does not perform an exchange function. The SEC goes astray because it misreads the statute's group of persons clause, treating that as a proxy for corporate affiliation, when what the statute actually requires is that the group together operate a marketplace or a market facility, neither of which Silex does. Second, even under the SEC's affiliation test, Silex is not a facility. Fundamentally, Your Honors, this case is not about whether the SEC may regulate CBOE Exchange, which is a registered national securities exchange. The SEC can and does. Instead, this case is about whether the SEC can regulate a software tool as if it were part of an exchange, even though it does not perform any function of an exchange, simply because it's provided by an affiliate. Let me begin with the court's permission with the question of the legal test. I think it's fair to say that the briefs tee up two competing tests for determining exchange status, what we call a functional test and what I'd label as the SEC's affiliation test. Under a functional test, a product or service is part of a securities exchange.
Where does one get what you call a functional test out of the language of the statute?
Absolutely, Your Honor. We think the text of Section 3A1, which defines what it means to be an exchange, speaks in wholly functional terms. There are two.
But there's no doubt that CBOE operates exchanges.
Correct.
We're dealing here with whether the Silex package is a facility of an exchange.
And that facility question, Your Honor, is decided both under the text of the statute and under the SEC's regulations by a functional test as well. Otherwise,
Yeah, that's why I'm asking you, what language of the statute are you relying on for the proposition that this test is, well, let's just say functional rather than formal?
Absolutely, Your Honor. I think the language is in Section 3A1, and it's the reference to a market facility. The Section 3A1 counts as part of an exchange, not anything that fits within the admittedly broad.
I would like you to discuss 3A2. The term facility when used with respect, etc.
Your Honor, our reading of Section 3A2 is that it identifies what is a necessary condition to be considered a market facility under 3A1, but not a sufficient. So in other words,
you flogged the word necessary in your brief too, but I can't find that either in the statute. I'm trying to see how your argument jives with the actual language of the statute.
Absolutely, Your Honor.
Necessary isn't there.
Your Honor, for the sake of this discussion, I think we posit that the facility definition is exceptionally broad. It covers the waterfront. There are 4 clauses to the facility.
That's very common in securities law.
No, absolutely, Your Honor.
Definitions are broad. Yes.
So the question is not in isolation, is something a facility? The question is whether, under our reading of the statute, whether it's a market facility, which is why 3A1 and 3A2 need to be read together. And Judge Easterbrook, if I could just point you to the language of 3A1, it defines what it means to be a market facility in 2 ways. It says a market facility is, quote, something that brings together purchasers and sellers of securities, or second, for otherwise performing functions commonly performed by a stock exchange. It's those functionalities that the statute defines as a market facility.
You completely lose me. 3A1 does not define the word facility. It doesn't contain the word facility. That word first appears in 3A2. So how does one say that there's some special definition of facility in 3A1, which defines exchange rather than facility.
Your Honor, respectfully, I'd push back a bit on the suggestion that 3A1 doesn't reference facility. It does. It references market facility. Our reading of the statute is that to be a market facility, to be regulated as if you are part of a securities exchange.
Where do I find the word facility in 3A1?
The last sentence says, the functions commonly performed by a stock exchange, as that term is generally understood, and includes the marketplace and the market facilities maintained by such exchange.
And then we turn to 3A2 to find out what the word facility means.
Correct, Your Honor. And our position is that market performs an important limiting function. The adjective market in 3A1 limits the types of facilities that count as if they are parts of exchanges. And if Your Honor is not persuaded that that's clear from the statute, I do think that is crystal clear from the SEC's own regulations, which we also discuss extensively in our brief. In 1998, nearly 30 years ago, the SEC defined what it means to be a system that brings together purchasers and sellers of securities, and it did so in decidedly functional terms. And it created specific exceptions for functions that count as exchange functions and exceptions in, activities that don't count as exchange functions, Your Honor. And respectfully, we think what the SEC was attempting to do in 1998 was bring coherence to admittedly broad and difficult to decipher statutory language in the Exchange Act. Because, and I do want to make this point, Your Honor, the SEC's interpretation, under which it's sufficient that an asset or service fits within the facility definition and is owned or operated by an affiliate of a registered exchange, would have astonishingly broad consequences that Congress simply couldn't have intended. And the reason that's so, Your Honor, Judge Easterbrook, is...
I always am very skeptical about couldn't have intended arguments. The Supreme Court has told us that we go by the language of the statute and not by imputing intent to the head of people who are all dead and can't tell us what they intended and didn't present their intents to the president for signature. Anyway, we've got statutory text, and it seems to the Supreme Court, and therefore to me, that that's where we stop.
Your Honor, I appreciate the point about statutory interpretation, but the point is I don't think the SEC has ever actually understood that you could read the statutes to that breadth either.
The SEC has, for the last 50 years almost, been making arguments to the Supreme Court about statutory intent in the 33 Act and 34 Act and getting its hat handed to it.
I don't know the total scorecard of that, Honor, but I'll spot you that. But I do want to just explain why yes, Your Honor.
You simplify your exchange function test. I think it's page 42 of your brief. I'm going to paraphrase, but you suggest that if a product performs an exchange function, it should be regulated under the Exchange Act, and if it does not perform an exchange function, it shouldn't be regulated. Now, how do you square that with tickers that are on many websites, with the DC Circuit's decision in Intercontinental Exchange? How is your definition consistent with that, and what would be the principle that wouldn't all of a sudden be both under-inclusive and over-inclusive?
Your Honor, we believe that a functional test captures precisely what a reasonable approach to exchange regulation would be, which means if something provides an exchange function, regardless of who owns or operates it, it should be regulated as if it were part of an exchange, regardless of corporate lines.
So isn't that reading out A1?
No, Your Honor, we don't think so. We think the critical language in A1, and I appreciate to Judge Easterbrook's point, it's not easy to square A1 and A2, that the word market facility in A1 is performing a limiting function. It's not the case that everything that fits in the A2 definition and is owned by an affiliate of a registered exchange could be regulated as if it were part of an exchange. And the reason, Your Honor, that can't be right is because there are 4 prongs to the facility definition. One of the first prong is premises and property. The second prong is tangible or intangible property. The third prong is any right to use a particular service. If the SEC were right that it's sufficient to fall within the facility definition and be affiliated with a regulated exchange, that would mean essentially every business line of SIBO Global Markets parent company and every affiliated entity could also be regulated as a part of an exchange, and Congress can't have intended that result.
It's entirely possible, but Congress often legislates more broadly than it needs to or than people think so. I also don't understand this affiliated with business. What the statute says is any service for the purpose of effecting or reporting a transaction on the exchange maintained by or with the consent of the exchange. It doesn't talk about affiliated with the exchange, it talks about the consent of the exchange. Is there any doubt that Silex operates with the consent of the exchange?
Only in the nominal sense, Your Honor, that one needs to connect to the electronic trading engine, but Silex.
In other words, it needs the exchange's consent.
Yes, but Silex connects. But Your Honor, the point is that there are dozens and dozens of unaffiliated OEMS products in the market that connect on precisely the same terms, that demand just the exact consent, same consent by the exchange. So if it were right that Silex is providing a market facility, then the SEC would be regulating all of those unaffiliated providers as well. But they've never taken that position, Your Honor.
Well,
and again, I suggest
we're
that
just trying to interpret the statute. Maybe, given the language of the statute, the SEC's got more work to do and not less.
Well, Your Honor, respectfully, we'd suggest that the 1998 regulations, and I do want to save time for rebuttal, but if I could make this last point, the 1998 regulations, Your Honor, we'd urge the court to read the 1998 release. What the SEC said as an example of a system that's excluded under its definition, it cited the common message switch. This is at 63 Fed Reg 70853. The primary example of an excluded system the SEC identified was a system that, in the SEC's own words, was owned and operated by the New York Stock Exchange and the American Stock Exchange. So if the SEC's approach that they're defending in court here today were right, that you can impute the exchange activities of SIBO Exchange to an affiliated company, a software company, SIBO Silex, and regulate that all as if it were part of an exchange, that would make the 1998 regulations and the regulatory exemption that the SEC set forth incoherent. What we're ultimately suggesting, Your Honor, is that the SEC has regulations on the book for nearly 3 decades that have attempted to reconcile the admittedly difficult exchange and facility definitions, and it's done so through an exchange function test.
I just don't see how it's difficult. I certainly see how it's broad. It may well be overbroad, but I don't see the difficulty in A2.
The difficulty, Your Honor, is in understanding what a market facility means in A1. Respectfully, we don't think the statutory interpretation can start and stop.
It's defined in A2.
Facility is defined in A2, Your Honor, not what it means to be a market facility. Our point is that reading the statute as a whole, as the Supreme Court's reminded the SEC it needs to do time and again, that reference to market facility has to do work, and SEC's regulations, we believe, make clear that what that work does is incorporate an exchange function test. And I've already eaten into my rebuttal time, but would respectfully request to reserve time for rebuttal.
Certainly, counsel. Mr. Hill.
Good morning, Your Honors. Ezekiel Hill on behalf of the Securities and Exchange Commission. I'd like to begin with the text of 3A1 and 3A2. And as this court's been discussing this morning, 3A2 and 3A1 work together. 3A2 provides the definition of facility. SIBO's argument seems to be that the commission is solely looking at corporate affiliation and concluding that Silex is a facility of the exchange. But that's simply incorrect. 3A2 is defining what facility is. Where the affiliation comes in is when we turn to 3A1. 3A1 defines an exchange in terms of an organization, association, or group of persons. And so the group of persons is an important limitation here on the definition of what is an exchange facility. That's one of the reasons why when an unaffiliated software, OEMS, of this product would not come within the definition of exchange facility if it is not offered by the group of persons. Here, because Silex and SIBO form a group of persons, Silex's software comes within the definition of a facility of SIBO. And the reasons that it is part of the group of persons, and this is consistent with the DC Circuit's reasoning in the Intercontinental case, is that first of all, they're corporate affiliates, they share a common corporate parent, making them part of a group of persons. But moreover, that would be sufficient, but in addition to that, they have a unity of interests and they act in a concerted fashion. And that's demonstrated by a few things, including the fact that as presently constituted, SIBO offers a waiver to users of Silex. So if you're going to use Silex to access SIBO's matching engine, you're provided with a waiver by SIBO. You won't need to pay the same costs that non-Silex users would need to pay. So that's the sort of concerted action that the DC Circuit saw created a group of persons among an exchange and its facilities. I'd also like to turn, if I could, to Rule 3B16. So 3B16 defines certain functionality is not coming within the exchange definition. But it's important to look at not only what functionality it's looking at, but whose function it is. So 3B16 speaks in terms of functions by an organization, association, or group of persons. It's echoing the statutory language from 3A1. And so when you're looking at whether a particular activity is exempted from the exchange definition by 3B16, you look not to what a particular facility is doing, you look to the group of persons. So here, if you look to the group of persons, that includes not only Silex, but also SIBO, and clearly it's undisputed, SIBO is providing exchange functionality more than simply order routing functionality, and so 3B16 does not provide an exception from the exchange definition. In addition, we heard a moment ago about the release for regulation ATS, which referenced certain order routing systems. And I'd urge the court to look at that regulation, at that release. The release is not, it's providing examples of order routing systems. It's not asserting that those order routing systems, when viewed as part of a group of persons, do not come within the definition of exchange. It's only providing examples of what an order routing system like Silex would be. And as the Commission noted in its order under review here, where the Commission's considered whether exchange-related order routing systems are exchange facilities, it's concluded that they are, and that's because of their functionality, which brings them within the facility definition, and also their affiliation with the exchange, which makes them a facility of that particular exchange. And SIBO, in its briefing today, doesn't identify a single instance in which the Commission reviewed an exchange-affiliated order routing system and concluded that it was not an exchange facility. I'm happy then to turn to the provisions of the proposed rule, if the court has any questions about that, or if the court has questions about the statutory definitions. All right, well, and with no further questions, thank you very much.
Thank you, Mr. Hill. Mr. Dunbar, anything further? Not much to respond to.
I'm sorry, Your Honor, I missed that.
Not much to respond to.
Well, Your Honor,
The time is your own.
I have the 2 minutes, so let me try and persuade the court on the statutory analysis this way. My friend on the other side began with the group of persons language in section 3A1, and candidly, I think this is where the SEC has really taken a wrong turn in its interpretation of the statute. The reason is that we don't dispute for purposes of this argument that it's possible to view the SIBO parent corporation, SIBO exchange, and Silex as if they're part of a group. But the statute directs the inquiry to what the group does. The group must operate a marketplace or market facilities. And just pointing to the group of persons language doesn't answer the question of whether the group together, as the SEC puts it, actually operates a securities exchange. The bottom line is that Silex is a software company. It provides an off-the-shelf product that many other unaffiliated OEMS providers provides that are not regulated as a part of an exchange. It doesn't run a securities exchange. Neither does any SIBO group. To parallel an analogy we offer in our brief, if my brother runs a restaurant and I write code for an AI company, we're certainly part of a family. But no one would say that the family runs the restaurant or that the family writes AI code. Each of the individual constituent parts do. And the SEC's test, which at bottom, Your Honor, is that if something fits within the facility definition and it's provided by an affiliate of an exchange because it's part of a group, we'd submit misreads and reads out of the statute, reads in such an expansive way the statutory group of persons language. The bottom line, Your Honor, is that the best way to look at how the SEC has interpreted this statutory text is to look to the SEC's regulations. They exclude certain functions and activities that count as exchange functions. They include others that don't. And order routing, which is the central functionality that's provided by Silex, the software product at issue here, is expressly excluded from the definition of what counts. We'd ask the court to hold the commission to its own regulations and vacate the order. Thank you.
Thank you, Mr. Dunbar. The case is taken under advisement. Our next case for argument today is Crescent against Elanco. Mr. Congress.
May it please the court. My name is Robert Congress. I represent the appellant Clayton Creason. Primary goal of the appeal is to revive or resuscitate the Rule 23 class action based upon the wage deduction taken that was called a vacation by.
Mr. Congress, you realize your client has lost. Is it your goal to take every other class member down with him?
Well, that has to do with the concept of the cart before the horse, and yes, I think that the class...
Well, you began by saying our main goal is to get a class certified.
It is.
Your client is lost on the merits.
He has.
If we certify a class and do nothing else, the whole class immediately loses on the merits. Is that Creason's goal? It does not seem to make him an effective class representative.
His goal is to prevail, but if it has to do with adequacy, that could be a problem. But we've also appealed the ruling on the merits on his ordinary individual vacation.
I could understand an argument. If he wins on the merits, then on remand, we'd like the class certified. But your brief just says, and what you've just said is, we want a class certified. Win or lose.
He wasn't given an opportunity to win on the merits because the motion was brought under Rule 12b-6, and his obligation is to prove that his claim based upon the wage deduction was plausible.
Where is his allegation of a deduction?
Throughout his complaint,
And what is his theory that there was a deduction?
$83.78 was taken from
I
each
got
paycheck.
that. It seems to me that you're just telling us, look at his pay stub without offering a theory of a deduction.
The allegations were made in the complaint, and they can be proved. What I attempted to do...
According to his pay stub, what was the base for tax? From what amount was tax deducted?
The categories were confused. It was called a post-tax
You
deduction.
can
It wasn't
figure this
pre-tax.
out by multiplication.
I can.
Yes, and no tax was deducted from the amount set aside for vacation pay.
No, but if I may, please, the real problem in this circumstance had to do with the concept, the very simple concept that every direction by an employee to take a deduction from a wage to be earned is a wage assignment. This was a deduction from his gross pay. He had a base
No,
salary
what
of
Elanco
$2,010
says
a week.
is that your client agreed to accept a lower wage in exchange for more vacation.
And that is not
And the
true.
lower wage, he was taxed on every penny of the lower wage, and then presumably taxed when he got vacation pay.
In Creson's case, it wasn't because he didn't get that, but that wasn't the plan. The distinction would really, and I apologize if I am not clear about this, I'm trying to be as clear as I can. The distinction has to do with the conflation of the concept of ordinary vacation pay with a benefit program where a deduction is taken to pay for an extra week of vacation. And the distinction is, in ordinary vacation pay, it is earned, and it is additional, and it is deferred. Those three words are key. Through his work, he would earn pay that he would be paid during an ordinary vacation week. With the vacation buy program, he took his own money and he purchased a benefit. He did not get paid any earned money as he would have in an ordinary vacation week with the deferred earned money. That is the distinction between the two things.
It is not how Elanco characterizes the transaction, and it is not how the transaction was subject to tax. If your client were taxed on this $78 per pay period, then I could understand your position. But Elanco's position, that your client agreed to a lower wage in exchange for more vacation, is the one that jibes with the tax consequences. Now, I would like to know why we should ignore the tax consequences.
I'm not asking you to ignore the tax consequences. We actually did research and we made an allegation in the complaint that there is a tax code under what is called a cafeteria plan. It's at Title 26, Section 125. One of the benefits in a cafeteria plan that can be purchased is up to one additional week of vacation time, up to 40 hours, subject to certain restrictions. The primary restrictions, and this isn't so much in the statute as it is in the regulation, but the restrictions are that the purchased vacation must be subject to an ordering rule where the purchased vacation has to be the last taken vacation time in any particular calendar year. Also, that purchased vacation cannot be carried over from one year to the next. That is the tax regulation that applies to purchased vacation. But in this circumstance, the primary issue is this was a 12B6 ruling. Mr. Creason alleged I had my earned wages, actually in paragraph 15 of the third amended complaint, he uses the phrase earned wages. A deduction was taken, and that deduction was not taken subject to a valid wage assignment under the Indiana Wage Assignment Statute. The statute itself and the case law thereunder make very simple the roadmap to victory for a plaintiff in a wage deduction claim. I believe I listed 7 cases, 2 were state court of appeals cases, and 5 were federal cases applying federal law, where a plaintiff won because he had a deduction taken from his pay without the employer first obtaining some form or piece of paper signed by the employee permitting the deduction and containing some type of language that said you may revoke this at any time upon written notice to the employer. The most severe of those cases came in a class action context. It was a case called Brian Weil versus Metal Technologies, Inc. Uniform deductions had been allowed by Indiana's amended wage assignment statute at 22262. However, the company, Metal Technologies, did have a form signed. You may take a deduction for the cost of my uniforms. It was signed by employees, but the form did not have the phrase, you may revoke this at any time upon notice to the employer. The class was certified. Liability was determined in the plaintiff's class's favor on a summary judgment ruling, and there was a trial on damages, and a recovery was made. That's the same thing here. And in terms of plausibility, I pointed out to the district court, and I've pointed out in our materials, that it would be plausible for Elanco to have had some type of form signed by Mr. Creason and his colleagues. You may take a deduction for me to purchase an additional week of vacation. Signed by the employee, acknowledged in writing by the employer, the legend, you may revoke this at any time in writing. And then the deduction had to be for a reason permitted by Section B of Indiana Code 22262B. Section 8 governs that. There is a provision that allows an employer to take a deduction for contributions to a fund or a plan that will pay a benefit to an employee. But for that to be proper, there has to be some type of a fund or a plan set up that the monies deducted would be paid into and then subsequently paid out of. So there was a roadmap, there was the case law, the language of the statute, and this would have been a very simple claim after the reversal of the wage deduction claim, which Judge Young referred to as separate and gave him the right to make a ruling on the Indiana wage payment claim separate from the individual claim. This would work, and then the case could be reviewed on the motion to certify. It should be certified because everybody had the same deduction and the same fact. They didn't sign a wage assignment form. That is it. Plaintiff was fighting a straw man argument the whole time, saying that these aren't earned monies, that these are deferred vacations, citing vacation pay cases that deal with ordinary vacation pay that is earned over time. We would ask that the Rule 12b-6 motion be reversed and the court on remand certify that claim. Separately, our second goal is the individual claim. Mr. Creason, Indiana law, which has to be applied, Supreme Court case is the Schaafstall case. The general rule is if you have accrued vacation time, when you depart, it is paid, subject to an arrangement. Basically, those are written policies with a forfeiture clause. One did not exist here, and the point that was not addressed by the court is there was a policy. The revised and most recent policy was January 1, 2021. It was specific to departing employees, and it said all company-provided vacation and all purchased vacation will be paid to the employee upon departure. Elanco relied on an email policy from November of 2020 that didn't talk about 2021 purchased vacation, didn't have an ordering rule, and simply said, we allow carryover vacation, you have to use it or you won't get it when you leave. That was not the most recent statement of the policy. So either the most recent policy applies or the simple general fallback rule applies. So if the court does not reverse the wage deduction theory and allow the case to go forward as a class, we would ask that Mr. Creason receive a reversal on the individual claim. There's a dispute about the amount of hours that are owed, but there was not a dispute that there were hours owed, and there was no basis to require him to forfeit his vacation pay. I'd be happy to answer questions, but I have 3 minutes I'd like to reserve.
Certainly, counsel.
All right, thank you.
Ms. Fisher.
May it please the court. My name is Rachna Fisher, and I represent Elanco. Elanco's vacation buy program allowed employees to have the flexibility to decide how much vacation they wanted to take each year. Employees could choose the terms and conditions of their employment to decide whether they wanted more pay or more time off. The district court correctly dismissed Mr. Creason's claim that the vacation buy program was a wage assignment. Under Indiana law, an assignment is a deduction from wages to be earned. Mr. Creason agreed at the outset to earn less in exchange for more vacation. Because there was no deduction from wages, there was no wage assignment. And because the district court correctly held that Mr. Creason's class claims failed to state a claim, it correctly denied class certification as moot. In Cowan, the court found that dismissal before class certification is a recognized tactic in some cases, And in any case, as this court pointed out, class certification would have benefited Elanco, not Mr. Creason, as it would have extended res judicata to the entire class. And Elanco is not appealing this issue. Finally, the district court correctly granted summary judgment on Mr. Creason's wage payment claim. In 2021, Mr. Creason had 3 categories of leave: earned leave, vacation by, and carryover leave. Importantly, Mr. Creason admitted at his deposition that at the time he left, he only had carryover leave, which was not payable. While Mr. Creason relies on the January 2021 Pay and Benefits Guide, it specifically said certain restrictions may apply to the payout of leave, and this was one of those restrictions. And so, unless the court has questions, Elanco respectfully requests that the court affirm the decisions of the district court.
Thank you, counsel. Anything further, counsel?
Very briefly, thank you. In rebuttal, 3 points I wish to make. First, in terms of this argument that Mr. Creason had agreed to a reduced salary, or what was called a proportionally reduced annual compensation. That is not true, but for purposes of our appeal, it is not what Mr. Creason alleged. One of the examples in argument that Mr. Creason gave to the district court and gave in his briefing to this court is the ability he had to prove that his salary had not been reduced based upon the 401k matches. He had the employer match, which was 6%. If you look at the pay stub that was attached to the complaint, it is a precise 6% of the 2010 per week base salary in that pay stub. The employee match, Mr. Creason used 10%. The amount deducted from his pay is deducted from his full $2010 per week base salary. He had $201 deducted. He had the ability to prove, he had the ability to plausibly say, I did, to defend himself from Elanco's argument, but he did not allege that he agreed to reduce his salary. That was not his allegation. The second point, saying that Mr. Creason said something in a deposition about his vacation pay, Indiana law is clear that an employee cannot waive his claim. That is the Stamco versus Guffey case, but it's also in the statute itself in 22251B, where any contract in violation of the Indiana wage payment statute is void. So he could not waive his claims. Finally, the question about which policy Elanco had in place. I argued to you that it was the most recent that was important, but it's also important that in this quasi-contractual circumstance that we use Indiana principles of contract law and these specific controls over general inconsistent policies. So in terms of there being a specific policy to departing employees that all company provided vacation and all purchased vacation will be paid to the departing employee is specific compared to an email policy from the year before that didn't refer to 2021 purchase policy, didn't create an ordering as Elanco had claimed, and simply said that the purchase policy. And finally, back to the tax order, in addition to the fact you couldn't carry over purchase vacation, there is no rule in place at Elanco, and there's no law that says you would order a 2020 carried over purchase vacation after a 2021 purchased vacation. Thank you, judges.
Thank you, counsel. The case is taken under advisement. We'll hear argument now in the case of United States against Suggs. Mr. Horwitz.
May it please the court, my name is Ben Horwitz and I represent the appellant Floyd Suggs. This court should reverse the district court's denial of Mr. Suggs' motion to suppress evidence. The district court erred in 3 main reasons in its decision. First, the search warrant was insufficiently particular. Second, the warrant was executed unreasonably. And third, there are no exceptions under the Fourth Amendment that excuse law enforcement's conduct. And I'd like
Mr. Horowitz, can I ask you a question? Assume the warrant itself was reasonable, okay? Assume the warrant itself, that they did sufficient investigation and did not determine that there were 2 apartments within the building. The officer delivers the package and rings both doorbells, right? That's what happened in fact. Then the officers enter the building, right? And if there were 2 apartments, your client has no particular privacy interest in the vestibule of the building or the foyer of the building, right? You agree with me there?
I think the case law is
Pretty clear
against
on
that, yes.
And then the agents conduct a protective sweep and walk through the first floor apartment and encounter Mr. Suggs in the rear of the apartment in a rear stairwell, correct?
Factually, yes.
Okay. In the district court, you never challenged the legality of the protective sweep. Is that right? You agree with that, right?
I don't think it was fully flushed out, but
where is the, once they encounter Mr. Suggs, if the warrant, assume with me, if the original warrant was valid, was reasonable, okay, because they did a sufficient investigation and did not determine that there were 2 apartments. Once they rang the 2 bells, they were allowed to go into the vestibule. If they were permitted to do a protective sweep of the first apartment, and whether they were or whether they weren't is neither here nor there because it wasn't challenged in the district court. Once they encountered your client with the purple dye on his hands, and your client fled up into the 2nd floor apartment and locked the door, first of all, at that point, don't they know where he lives such that the warrant is valid under garrison? And even if it wasn't, don't all kinds of exceptions apply? Exigent circumstances, inevitable discovery. He had the dye on his hands. They knew who it was. They went to get him. Where am I, in that scenario, where do I fail?
well, I'd like to address your question as directly as I can, and I think
Okay.
the place to start is with exigent circumstances. Now, in this case, it's not disputed that law enforcement had removed any controlled substance. There was no factual allegation that drugs were in either of the units.
Right, but if they would have stopped everything, if they said, we gotta call the judge, we gotta get a new warrant, wouldn't your client have had the opportunity for many minutes and maybe an hour or more to destroy the relevant evidence?
There are not facts to support that there was evidence to be destroyed at that point.
Well, it was his hands.
And respectfully, and I'm not sure that the science behind this, but my understanding of the purple dye is that it's not something that can be easily washed off. So as far as the exigent circumstances are concerned, there is not the exigency of somebody's physical safety, of somebody in need of medical attention, and I don't believe that there's the exigency of the destruction of narcotics. So the exigent circumstances doctrine does not support entry at that point, and certainly even in the back stairwell, there is the need to obtain this more particularized and specific warrant. And I
At that point, when they encountered him in the back stairwell and he goes up into the 2nd floor apartment and locks the door, now they know there are 2 apartments. They only have a warrant for one, basically. They only have a warrant for 1 apartment where Mr. Suggs lives. Now, why isn't the warrant sufficient for them to enter the 2nd apartment and conduct the search pursuant to the warrant? In other words, why is the warrant invalid at that point?
And that, I think, is the problem with the question, because it condenses the timing and when law enforcement knew what. And this is exactly the execution portion of our argument and why the execution was unreasonable. So even assuming that the investigation was sufficient such that the particularity prong was met, and I'd like to address that later, but a warrant that on its face justifies entry into a single unit building at 11:19 a.m. when Agent Coyote approaches the first doorbell, rings the doorbell, rings the 2nd doorbell, at that point, there's a reasonable inference, and they knew or they should have known that the place to be searched was not the place authorized for search.
Why? Just based on I have 2 doorbells. I don't have I don't have 2 apartments in my house.
Frankly,
It's an odd thing. I don't know why we have 2 doorbells, we just do.
I'm not familiar with the specific facts of your house, but
No, I understand.
But frankly, that's the point, is that would it be reasonable to go to your house and see 2 doorbells, to ring both doorbells thinking that it was a single family unit, and then to burst down the door under the authority of that warrant? And the answer is no. So what we have, and this is why the execution prong is...
But once they broke down the door, they were just standing in the foyer of the building. There's no there there. What's the problem with that?
I think it's instructive to look at a case like Ritter. And in Ritter, the court found that there was a sufficient investigation. The court found that up until a certain point, the execution of the warrant didn't raise any problem. And when law enforcement learned that the place authorized for search was different, of that discrepancy between single unit and multi-unit, it was a question of where they were when they knew that. And the conclusion in that case was they were obligated to stop the execution of the warrant at that point. They were acting under the authority of that warrant. In that case, in Ritter, they were in a common area, but they were still obligated to stay in that common area at that point, and that's what the Third Circuit held in that case. In this case, they're not in the common area at the time that they should have known that the warrant did not authorize search into this building. And we should look to footnote 7 at page 33 of the appendix, in which the district court found that it would have been preferable for law enforcement to apply for a more particularized warrant. However, it's unclear how law enforcement could have known which unit to request an updated warrant for. So to simply ignore the particularity and ignore the investigation, to ignore what happened at 11:19 a.m., to find that it was, I don't know how the court would characterize it, but 2 doorbells, just like Your Honor's house, that should have raised alarm bells that, that this was not the place authorized for search. And then to continue with the execution with the battering ram through the front door and into the common area, the question is, was there a constitutional violation preceding that that made the execution of the warrant unreasonable? And
But if there wasn't, that's the problem I think that you have. If there wasn't, if there was not a constitutional violation preceding their entry into the building, and if your client did not have purple dye all over his hands, the case might be different. In other words, I don't know that there's extras in circumstances if they encounter somebody in the back stairwell and the person in the back stairwell walks up the stairs, goes back into the apartment and locks the door. I think it's the purple dye on his hands that creates the problem for your client.
And I'm arguing that the constitutional violation preceded that.
Right.
So I think the government kind of inaccurately likens the circumstances in this case to both Kelly and Nestor. In Kelly, we have a situation where law enforcement's on the threshold of the door. They go through the door and they're simultaneously able to determine that this place is not the place that's authorized for search, but also they're able to dispel the possibility that they're searching the wrong place. That is not what happens here. The information gathered by law enforcement starting at 11:19 a.m., confirmed by the entirety of the search team through the live stream of the body-worn camera of Agent Coyote, and continuing up to the threshold of the door, everything that they learned from there was in the opposite direction of the disparity between the search warrant and the place authorized for search.
Let's say you're right on that. Let's say they determined immediately that it was a 2-building apartment. They rang both doorbells and they realized right away that there were 2 apartments in the building. Couldn't they have then entered the building without a warrant? It would have been foolish for them to do that. I mean, the reason they don't generally do that is they don't want to announce their presence, and they don't want to, indicate to people like Mr. Suggs that we're on to you, right? I mean, it would have been a little weird for the agents to break down the door, enter the building, realizing it was a multi-unit building, and then say, well, we can't go any further, so now we're going to leave and come back and get a search warrant, and we'll see you in 3 days. My guess is Mr. Suggs would not have been there. That's my guess. So they usually don't do that. But they could have, right?
I think it's questionable legality for law enforcement to go around. We're starting from from the founding. The Fourth Amendment establishes this principle that protects against general searches. And so is law enforcement allowed, under no authority of a warrant, to just batter down the front doors of buildings and hope that it's a common area on the other side of that door? This is law enforcement.
But if it is, what's the problem?
The
There's
problem,
certainly, they can walk into the lobby of the JW Marriott Hotel today, they can walk into the lobby of the, apartment building in Chicago, they can do that.
well, I would like to return to particularity at some point, but from there, even if they get to the back stairwell where they observe Mr. Suggs' purple dye going into the second floor unit, there still is no exigency. There is no safety risk. There is no narcotics that's subject to destruction because there are no narcotics known to be in the residence.
I'm a little confused with your exigency argument. It seems like you're saying because they didn't find drugs, there was no exigency. But certainly the package didn't have drugs, but the package itself was evidence. There's reason, this is a controlled delivery. He has purple dye in his hands, runs upstairs. Are they not to follow him out of fear of destruction of evidence and go get a warrant at that point?
They are to get a warrant at that point. At that point, we have a 15-person law enforcement team blocking the front and the rear exit to the building. And it would have been preferable, we agree with the district court, it would have been preferable to get a warrant.
And you don't think in that situation there's a risk of destruction of evidence?
Not based on the specific facts at that point. The controlled substance had already been removed. I would briefly, if I could, just return to particularity. As the court is aware, Garrison is the seminal case here, and it was not objectively reasonable based on the information that was known or should have been known to law enforcement prior to the issuance of the warrant to believe that the two-flat was a single unit residence. The district court found this to be a close call, but unfortunately it came down on the wrong side of it. So I appreciate the hypothetical in imagining that this was particular. It was, however, not. The lead agent failed to ask the probation officer about the layout of the residence. They failed to look at a publicly available resource like the Cook County Assessor's website, failed to investigate the implications of multiple garbage cans, failed to recognize what I'm sure the court is aware is a standard two-flat, and failed to speak with somebody who would have been present on a daily basis at this resident in the postal carrier. The investigation failed to take the opportunity to look into reliable, readily available resources. The opportunity and this information that was available to law enforcement is much stronger than what the case law lays out, which in various cases is a confidential informant, somebody who has a criminal history, is involved in crime, not the reliable individual that would be a federal employee in the probation officer who would have had firsthand knowledge of the layout of the two-flat. So for that reason, I would urge the court not to accept that the particularity prong has been met. Particularity and reasonableness have not been satisfied. And I would, unless there are further questions at this point, I would like to reserve some time for rebuttal.
Certainly, counsel. Mr. Choi.
May it please the court, Chester Choi on behalf of the United States. The court should affirm the district court's order denying the defendant's motion to suppress. First, here, the search warrant was valid when issued. In the context of this investigation, which law enforcement intercepted a package that contained approximately $20,000 worth of fentanyl pills, his investigation was reasonable. He consulted two postal service databases, the CLEAR database, which pulls from multiple sources, and it also identified two residents through the Illinois Secretary of State database who listed their address without listing a unit. It also involved a review of exterior photographs, and he also consulted with members of his team who had raised no concerns about the description of the premises. From there, the search was conducted reasonably. Law enforcement entered the front vestibule area, which is a common area, which they were lawfully and rightfully present. They then conducted a protective sweep, and within 5 to 10 seconds of entering, they heard footsteps on the second floor. And then within 2 minutes of entering, they encountered a defendant who had purple dyed stained hands, was manipulating a bag, and had also ignored law enforcement's commands to stop, and then locked the door of his apartment. So from there, law enforcement had identified the intended recipient of the package, which had contained drugs, and they had also identified the targeted apartment to be searched, and their search was limited to that apartment only. And even if this court were to find that the entry of the second floor was unreasonable, there were exigent circumstances. Again, they encountered the defendant with the purple dyed stained hands. He was the intended recipient of the package. When they searched the apartment, they did indeed find drugs. They found drug paraphernalia. They found wrappings with drug residue around the toilet. And at that point, with all that evidence, a search warrant would have been obtained and the evidence would have inevitably been discovered. If there are no further questions, the government requests that the court affirm the district's order denying the defendant's motion to dismiss.
Thank you, counsel.
Thank you.
Anything further, Mr. Horowitz?
Just to follow up on the issue of exigency, it's important to note that the execution of the warrant started at 11:19 a.m. The door was not battered down until 2:30 p.m. The knowledge of the two doorbells, however quirky and whatever inference the court believes can be reasonably drawn from that, there was no further investigation. This case is like Patino, in which there is a decided waiting period, a failure to investigate further, a failure to get more information, a failure to obtain a more particularized warrant, and a warrant that accurately authorizes the search of the two flat. And so it is the conduct and the failure to act by law enforcement that the government is now seeking to use to its benefit as far as the exigent circumstances are concerned. So I would ask the court to consider that as well. King directs us that the exigent circumstances doctrine cannot apply following an actual or threatened violation of the Fourth Amendment. The Fourth Amendment was violated starting when the particularity prong was failed to be satisfied, but also as starting at 11:19, the two doorbells were discovered and further information indicated to a reasonable person that this was not the place authorized for search. For those reasons, we're asking the court to reverse the district court's denial of Mr. Suggs' motion to suppress evidence.
Thank you, counsel. The case is taken under advisement. Case number 4 is Polk against Progressive Northern Insurance Company. Mr. Wormwood.
May it please the court. Good morning, your honors. Good morning, counsel. My name is Christopher Wormwood, and I represent the appellant in this case, Thomas Polk, in his individual capacity and in his capacity as administrator of the estate of his late wife, Kasia Polk. Your honors, this appeal presents a question pertaining to insurance contract enforcement, namely whether Progressive and Secura can avoid paying their proportionate share of the Polk's underinsured motorist claims by relying on payment amounts paid by another UIM insurer. The district court's decision effectively decided the answer to that question was yes, and that decision respectively was an error. The plain policy language, the UIM statute, and public policy all suggest the answer should have been no. The fundamental error in the district court's decision lies in the court's failure to recognize and enforce the plain unambiguous policy language that governs Progressive and Secura's proportional
I'm
payment
puzzled.
obligations.
Each policy has a clause saying the maximum payable from all insurers together is the maximum on the highest policy. That's $1 million on the AMCO policy.
That's right.
Okay. So your client has received, under the judgments, $1 million. What's left for this appeal?
My client has not received $1 million, Your Honor. My clients received $100,000 from the tortfeasor. That was the third-party payment.
Right, $800,000 from AMCO.
Correct.
And $100,000 from SECURA.
The $100,000 was offered by Secura. That was not accepted, Your Honor, and in fact,
It's
the
part
offer...
of the judgment in this case from which you're appealing.
Correct.
So by the time of the judgment, your client is entitled to $1 million. I understand you think Progressive should pay more, and Secura, if that's how it's pronounced, should pay less, but Secura hasn't appealed. And it's no skin off your client's nose who pays the other $100,000, which is why I'm puzzled.
Well, it is, Your Honor. There is a fundamental problem in that, and that goes back to the district court's fundamental problem in its decision in failing to recognize proportionate payment obligations. That comes from the other insurance provisions that are contained in both contracts. Judge Easterbrook, you had just mentioned, stating that they will only
So are
pay...
you suggesting that perhaps Progressive should have paid the other insurer its share of the $800,000 settlement?
No, I am not suggesting that, Your Honor, because I believe both our clients are entitled. They have individual claims. Thomas Polk has an NIED claim. Kasia Polk has a
But how can
wrongful
the
death
provisions
claim.
work together under your theory? They can't. You just want to read out of the entire contract the limit, the policy limit, or the anti-stacking provision.
Right. Well,
You just want to ignore it.
no, I'm not asking
How
that.
do you deal with it then?
Okay, so the anti-stacking language, you need to first look at the statute. I think it's important to consider that because that language helps guide.
Well, here, let me just
the
read
plaintiff's
it to you.
position.
Let me just read it. If this policy and any other policy providing similar insurance apply to the same accident, the maximum limit of liability under all the policies shall be the highest limit of liability under any one policy. That's $1 million. What do you do with that?
Are you referring to Progressive's
Yes.
policy there?
Correct.
Your Honor, Secura has similar language. However, Secura's language mirrors what the statute actually says. And I think you have to first look at the statute, which is 2015 ILCS 5/143A2. And what it states in there under subsection 5, nothing herein shall prohibit an insurer from setting forth policy terms and conditions which provide that if the insured has coverage available under this section under more than one policy or provision of coverage, any recovery or benefits may be equal to but may not exceed the higher of the applicable limits of respective coverage. It doesn't say all insureds, it doesn't say all recoveries. It's phrased in the singular that is if the insured
Isn't that
any,
Mr. Polk?
any recovery. Well, there's two claimants. Kasia Polk, his deceased wife, has a wrongful death claim. That's one insured under the policies. Mr. Polk has an NIED claim for his injuries related to the accident. He is another claimant. He's an individual insured. So that's the fundamental error with the district court's decision.
I'm now completely lost. You're asking us to ignore the actual language of the policy. You're referring to a state statute that, so far as I can see, on your own argument, is completely irrelevant. Right? The statute says, nothing herein prohibits X. You seem to be saying that any such clause, nothing prohibits X, means everything other than X is prohibited. Where do we get that in the statute?
Well, you have to read and construe the statute according to its plain terms. And the terms of the statute are phrased in the singular.
The plain terms of the statute is nothing in this statute prohibits X, and we can put X in. And you're saying this implicitly means everything other than X is prohibited. There was an old joke that in Italy, everything that is not prohibited is allowed, but in Russia, everything that is allowed is prohibited, right? You're just saying that everything that is not expressly authorized in Indiana is prohibited. And where do we get that out of state law?
Well, with respect, Your Honor, it's Illinois law.
Sorry.
But that's okay, that's okay.
It's okay. Where do we get that in Illinois law, that everything not expressly allowed is prohibited?
Well, there was the legal maxim that we cited in our brief. I'm going to butcher it, but in essence, what it means is that if the legislature said X, it intentionally did not intend for Y. So what we stated is what we meant. If we would have meant something else, we would have provided it in the statute.
We are accepting that the statute means what it says. What it says is that a certain kind of clause, that nothing in this statute prohibits a certain kind of clause. And you are arguing that therefore every other kind of clause is prohibited. Where do we find that in the statute?
Again,
it's not there.
It's in the text, but it's the phrasing that was used and the words that were deliberately chosen by the legislature, choosing the word in the words "if the insured," not "if the insureds," or stating that any recovery in the singular as opposed to all recoveries.
Oh, look, but you were here for the first case?
I was.
Right. The SEC issues a lot of things that it calls safe harbor regulations. And there was talk about a safe harbor regulation. The safe harbor regulation says A, B, C, and D are not prohibited by this statute or these regulations. On your view, that means E, F, G, H, I, everything else is prohibited. I'm not aware that the SEC or any court has ever reached such a conclusion. You could write a statute that says everything that is not expressly allowed is prohibited, but I don't see that in this statute. You haven't referred us to any case law saying that. I mean, so where does it come from?
It only, again, comes from the language of the statute, Judge. If there was a case that supported that, we would have cited it. That particular issue is a matter of first impression. But I want to go back real quickly, as I see my time is running out, to one of the fundamental problems with the court's decision, and that's that it eliminated the proportionate payment obligations that are independent on each of the insurers. And one thing I'd like to mention very briefly.
I don't see how that's where I began. I don't see how that is an argument of any concern to your clients. I can see how it's an argument of concern to Secura. But if $1 million recovery is the maximum under all policies, which policy pays it seems to be a matter of indifference, unless you think Security is bankrupt. If it is, then there's a problem.
No, I think each company has a proportionate payment obligation to fill their proportionate share of the gap. That's what's required. AMCO was responsible for 50% of the underinsured motorist gap. Secura and Progressive are each respectively responsible for 25% of that gap.
So have your clients offered to give AMCO back $300,000?
They have not, Your Honor. It's important to also remember the fact that $800,000 was offered as a global settlement to resolve that litigation that involved the Polk's UIN claims, both of them, and in addition to that, the bad faith and breach of contract claims as well. That was a settlement.
Thank you, counsel.
Thank you, Your Honor.
Mr. Stauder.
Good morning, and may it please the court. Michael Stauder on behalf of Progressive Northern Insurance Company. The district court's ruling should be affirmed because it correctly found the policy terms were unambiguous and the UIM coverage purchased by the Polks has been exhausted. When analyzing an insurance policy, the court looks at the plain and ordinary meaning of the policy terms. The Progressive policy unambiguously provides combined single limit coverage as expressed in the declarations page and the limits of liability section, which states that that is the most Progressive will pay regardless of the number of claims or insureds arising out of an accident. The plaintiff's argument that this applied per individual is inconsistent with the plain language of the policy. That payment obligation was subject to the provisions of the anti-stacking provision, which, as the court has acknowledged, capped the total amount of UIM coverage at the AMCO limit. The plaintiff's argument as to the anti-stacking provision is flawed for two reasons. One, it's inconsistent with the plain language of the policy terms, and the courts have routinely ruled that anti-stacking language, substantively the same as Progressive's, is not ambiguous. These anti-stacking provisions have been repeatedly enforced by the courts, and the courts have rejected arguments that these are against public policy because they closely mirror the language of the UIM statute. Two, the plaintiffs are reading the anti-stacking provision in isolation. The court must view the policy as a whole, and not in a way that would render one section meaningless. And so the anti-stacking provision must be read in conjunction with the limit of liability section. The purpose of UIM coverage is to bridge the gap between the tortfeasor's insurance and the coverage purchased by the insured. Under the anti-stacking provision, the UIM coverage is capped at the $1 million limit, and after the setup from the tortfeasor, there was a gap of $900,000. That gap was met, and that extinguished the UIM coverage. The case law makes clear that UIM coverage is not intended to allow the insured to recover over and above their UIM limit, which is precisely...
Now, I know this is not technically at issue in this appeal, but why was it appropriate for the district court to require Secura to pay $100,000 and Progressive to pay nothing? I could get $50,000 each.
Your Honor, I appreciate that question. I think it goes back to the purpose of the UIM coverage, which is to make the insured whole. And in this case,
Look, I've already said I don't understand why Polk is appealing, because the judgment collectively entitles the plaintiffs to $1 million. I'm asking about the relative shares of Progressive and Secura.
And Your Honor,
it just seems very weird for the district judge to say, well, Secura had offered more than $100,000, so I'm ordering it to pay $100,000 and Progressive nothing. Presumably the legal entitlements are what influences the judgment and not earlier offers.
and Your Honor, if I'm understanding your question as to why it wasn't split 50-50, that remaining $100,000, why it wasn't split 50-50 between Progressive and Secura, I think that would have been appropriate if the Secura money had not already been offered to the Polks. And so
what somebody has offered in settlement shouldn't be what a district judge orders in a judgment, unless it's legally required. The judgment is supposed to reflect the law and not bargaining positions.
Understood, Your Honor. And my reading of the district court's ruling was that initially Secura had offered even beyond the UIM limits of $1 million. And so it was bringing that back down to the limits that had been subject to the policy provisions. And in that case, as I had said, the purpose of that UIM coverage was to bridge the gap, and that money was on the table between the AMCO $800,000 and the Secura dollar. And that was done before Progressive had made its offer. And so the combination of those two payments from the insureds had extinguished Progressive's obligation. Given that that the Polks were made whole pursuant to what they purchased, the district court's ruling should be affirmed. I have a little bit of time left. I'm happy to answer any other questions the court may have. Thank you.
Thank you, Mr. Stauder. Ms. Ross. Let me ask you the same question I asked Mr. Stauder. Of course, you haven't appealed, so this is not before us.
Good morning, Your Honors. Andrea Ross for Secura. May it please the court. Yes, Your Honor, I anticipated you would ask that question to me as well. In terms of the judgment of the district court, of course, I would have thought that the district court would have split it 50-50 based on the pro rata clauses in the insurance policies. Secura's assessment and my assessment in the lower court was all based on the policy language, and obviously the pro rata clause is in the Secura policy and the Progressive policy, I would argue are applicable here. I did not appeal that issue because at the end of the day, the court did grant summary judgment in favor of Secura and Progressive, and at that point it was not a decision that Secura wanted, nothing that we were going to end up appealing. However, I do think based on the policy language that there should have been a split of 50-50 of that judgment. The reduction of the policy limits by the 800 from AMCO, I believe the case law did support that for the district court's decision. However, based on the fact that in acting in the best faith possible as an insurance company and based on the policy language and not knowing the terms of that settlement, that was the reason that Secura argued the way it did.
But your policy and Progressive's policy is not the same. Progressive's anti-stacking language is if there is other applicable uninsured and underinsured motorist coverage, we will pay only our share of the damages. And then it continues to say if this policy and any other policy providing similar insurance apply to the same accident, the maximum limit of liability under all policies shall be the highest limit of liability. That's Progressive. Secura, your policy says any recovery for damages under this policy and any other policy issued by us. So you're limiting it to policies issued by Secura, it sure seems like. There's some language that could present some ambiguity later about other insurance. And then in the district court, it sure seems to me like you were taking the position that under a reading of Secura's policy, the total you owed, given the prior payments, was over $100,000. You said this is page 7 of your memorandum in support of summary judgment. It's undisputed Secura paid the plaintiffs $5,000, right? So you're establishing the set-offs. The total of $250,000 that plaintiffs are entitled to recover under the Secura policy should be reduced by that $5,000. And then obviously you have the pro rata portion of the $100,000. And you in your brief at that point are saying that plaintiffs are entitled to recover in underinsured motorist benefits under the Secura policy $220,000. So why now should we read your policy the same as Progressive's policy and say the only amount owed is $100,000?
My argument in the district court was that that was the correct allocation because I did not argue that I argued that $500,000 should have come from AMCO, and that was it. They paid $800 in a settlement, and we didn't know the terms of that settlement. I know there were other allegations in the complaint against AMCO, which is why I argued it the way I did. I understand Your Honor's point on that. I just think the pro rata clauses in all the policies are clear that the remaining limits, whatever they are, should be split on the pro rata distribution, which the policies speak to. And so that's the reason I would think that it should be split 50-50. The court ruled the way it did, and we offered to pay the judgment to appellate, but they took this up on appeal. If there are any other questions?
Thank you, counsel.
Thank you.
Case is taken under advisement, and we'll hear argument now, United States against Whitesides. Mr. Leon.
Thank you, Your Honor, and may it please the court. The district court erred both legally and factually in triggering the drug premises enhancement, and those errors were not harmless. So we respectfully ask the court to vacate and remand for resentencing without the drug premises enhancement. I would like to start with the legal error. To support the enhancement, the record had to show that a primary purpose of Mr. Whitesides' home on Spruce Street was to manufacture, distribute, or store drugs. Mr. Whitesides lived in his home for 5 months before the arrest. Nothing in the record ties drugs to this home for the first 4 months of his residency. The record does show that he completed one drug sale during the final month of his residency, and the record does show that officers found less than 1 pound of methamphetamine and drug trafficking material on the last and the final day of his residency. This court's cases prove that is not enough to support the enhancement.
Well, that can't be right. If I lived in my house for 20 years and started using it at drug premises for only the last 6 months, I certainly couldn't argue, Judge, it's not, look, I lived there drug-free for 19 and a half years. Yeah, the last 6 months, certainly I used it as a drug house, but not for the first 19 and a half, therefore it can't be a drug house.
Well, that's not our argument, Your
Well, that's
Honor.
what you just said. You said
No.
for 4 months, there was no evidence. He lived there for 5 months. For 4 months, there was no evidence of drug dealing from the house. So what? That's my question.
Well, my answer is that I was just setting up the facts as they are, and conceding that there were some drug trafficking material in the home on the last day. But
Why
the
was it
government
the-
has the
was it
burden to
when?
prove that it was there for more than 1 day.
Why?
Because it's their burden to prove.
What difference does it make if it's more than 1 day? I mean, you convert it to a drug house on day 100, and you're arrested on day 100.
Because the record has to show that a primary purpose of this home was to manufacture, store, or distribute drugs. And I don't think
Where's the
something
temporal
being...
range? What's the temporal range?
Well, I would look at the court's decision in Kraft and Montgomery. So in Kraft, the defendant conceded that he had drugs there on several occasions, that he stored drugs on several occasions, and that he even used the drug proceeds to pay for his rent. This court said that was not enough. And so I don't see how you could square Kraft and also this court's case.
Mr. Leon, what it seems to me is that you're arguing the DEA should not do 1 controlled buy, they should do 4.
No, they should show with evidence that drugs were in this house on more than 2 occasions during the entire stay, and they didn't.
Yes, so more controlled buys would do it.
No testimony from an officer. They could have asked this officer on the stand to provide testimony on which days or any specific days that drugs were in this house, and it's just not there. And I don't think the stash house enhancement applies whenever the officers find drugs at home. That's not what this enhancement is about. And the commission said, we should compare lawful uses to illicit uses. And that's somewhat difficult in the context of a home because you're going to use a home for several lawful uses every day. But I don't think 2 illicit uses in the record can show that a primary purpose of his home, where he raised his children part-time, slept there, cooked there, ate there, was to distribute or store drugs. And so also, Your Honor, I think the government's brief, I would like to point out, it doesn't really dispute that 1 drug transaction and 1 day of storage failed to trigger the enhancement. The government instead thinks those 2 facts, combined with the government's allegation that he sold drugs away from the home, and that the government's allegation that he used the proceeds to finance his living expenses, show that drugs were there for several months. But that just, again, going back to Kraft, it can't be squared with it. As Kraft explained, any alleged drug transactions by Mr. Whitesides away from the home at least suggest that he did not use the home as a premises. Otherwise, if it was a premises, why not just sell them there? It defeats the purpose if you're going to leave the drug premises to go sell drugs. And the government's allegation that Mr. Whitesides used the drug proceeds to finance his living expenses, 1, is not a finding of the district court, and 2, again, falls under Kraft because there the defendant conceded that he used the proceeds to pay his living expenses. For those simple reasons, we don't think the record can support the drug premises enhancement. I think the court drew a plausible red line in Montgomery and Kraft, and it should not and need not contradict those cases here. Now, I would like to move to harmless error unless the court has questions about the merits. The government bears the burden to prove the district court's mistaken guidelines calculation is harmless. The government must show that the mistaken guidelines range did not affect the district court sentence in any way. This court has said that is a high bar, and it is one the government cannot meet here for many reasons. First, it's no stretch to conclude that the mistaken guidelines range affected the 188-month sentence because the district court told us it did and even showed us that it did. On Appendix 102, the court states that it considered, quote, The sentencing range established for the applicable category of offense committed by the applicable category defendant as set forth in the guidelines. The district court then showed that the mistaken range affected the sentence in some way when it chose the precise sentence of 188 months, which is 15 2/3 of a year, that remarkably happens to land right at the top end of the wrong range that it landed at. I'm aware of no prior case in this circuit or in any circuit affirming an inoculating statement when the district court explicitly said it considered the mistaken range, considered the specific offense level, and landed at a precise sentence at the top of the mistaken range. Second, and independently, I would like to point out that the district court's attempt at an inoculating statement vaguely relied on the circumstances of the offense, but the parties agreed that the district court misunderstood the circumstances of the offense in at least two ways. If the inoculating statement is not based on the record, as it should be, the statement must fail. Otherwise, we get really close to a due process violation under this court's precedent. I think just the fact that the district court said it considered the guidelines range twice and landed at 188 months is enough to show that the government cannot meet its burden. But should the court go further and actually address the inoculating statement, I think it fails Van Zyck's test. The inoculating statement must explain the parallel results, must illustrate how the error did not affect the ultimate outcome, and be detailed. But the district court never even mentioned the drug premises ruling in the 3553A analysis, never explained how his decision was untethered to the guidelines range or how 3553A excused consideration of the guidelines range. I think that is enough to reject the statement. If the court has no further questions, I would like to reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Mr. Clark.
Colin Clark on behalf of the United States. I'd like to start with a couple of record corrections. On page 2 of the reply brief, the Winfield case is described as that there were 5 occasions where there were pounds of drugs. It should have been ounces. On page 2 of the reply in that same chart, the Zamudio case refers to 10 pounds of drugs. It should have been kilograms. On page 8 of the reply, the Second Circuit Esteris case was described as being decided on plain error. Although the court generally described plain error, the issue we cited was not decided on plain error. The co-defendant's similar argument was, and we didn't cite those pages. The record, specifically the PSR, states that Ms. Kenesha Moreland and Mr. Whitesides shared equal physical care of their children. It doesn't say where or how, and it says that those kids used to go to Mr. Whiteside's house after school. But the brief, specifically pages 3 to 4 of the appellant brief, says that the children would exit the school bus at the Spruce Street home every day after school. And those details just aren't in the record, and that Kenesha would then pick up the children later in the evening or at night for the next school day. It's not there. And while, as he says on page 3, that the children might have stayed there on evenings and weekends, again, the detail's not there.
Counsel, let me back up for a second. This case is primarily about applying the enhancement.
Yes, Your Honor.
When drug dealing paraphernalia is found after a search. There's very limited evidence of ongoing drug activity at that particular residence before that. There's a record that could be read either way. There's 2 different residences. There's some reference to Snapchats, but nothing in the record as to how often that particular residence was mentioned in the Snapchats. And so what's your limiting principle for application of this enhancement? Because in Ford, we said that was likely the outside edge of this enhancement. How do you limit this enhancement to not apply to every time there's drugs found at a house?
This court has said that there are 3 main factors defining this enhancement. One is control. There's no dispute that Mr. Whitesides had sole control of the Spruce Street residence. Second is duration. The outer limit is 2 to 3 months. This is double that at 5 months. The third factor.
What's your evidence that it was used for 5 months as a drug premises?
So at pages, I believe, 38 or 39 and 61 of the transcript, there's discussion of there being a drug sale at or around the 7th Street house once a week during December, January, and February.
But we're not talking about the 7th Street house, right?
The whole purpose of the drug transactions is to talk about storage. And in order to meet a 1-week drug transaction, there must be drugs. For a consistent demand, there must be a consistent supply. And so we have drug transactions elsewhere in Terre Haute in December, January, February, weekly. And then we have the known buy in April. And so what the PSR said at page 32 is that based on the record the probation officer had, that Spruce Street house was used to store methamphetamine. And the district court, after hearing the testimony, adopted that finding of fact. And so what we have is in 4 of those 5 months, we have drug transactions. And so similar to this court's case in, say, Contreras, where you have drug transactions over 2 months and then 1 later in the fall, this court's cases fit easily with this record. In fact, our record, in terms of the amount of those transactions, is arguably better. So then we also have the scales and the empty box of bags and the gun and the 422 grams of methamphetamine found in the house. All of that suggests that that is where the drugs were stored, because the drugs were there and there's materials to package and sell and protect those drugs. And then we have the $14,000 to then go buy more drugs. To have, on top of his liabilities, his personal liabilities, the rent, car payment, etc., to have $14,000 in hand to buy, as the factual basis says, a large amount of drugs, he must have had a substantial number of transactions to meet that demand. And so everything goes back to, was there a consistent demand over the course of these 5 months? And how was that demand met? Based on this record, which, as you say, can be read in multiple ways, the district court, by adopting the probation officer's finding, decided to read it in a way that those consistent transactions were met with consistent supply of drugs at the house. Now, had he attributed the 316 grams at South 7th Street to Mr. Whitesides, which he did not, we would have a problem with the stash house enhancement. And so the limiting principle is that if he had attributed those 316 grams, we would have had to concede error on the stash house enhancement because there was no control over that South 7th Street house. There's no evidence that he sold drugs there, and there's evidence that people were in and out of that house all the time.
So if Judge Sweeney had done what you asked below, there would have been error?
Yes. And I don't want to beat around the bush about that. There are a few issues in this record that we're going to admit in terms of, we wrote something in the PSR that we didn't end up proving, which is irrelevant because of the location of those items.
But doesn't the fact that there's 2 houses still come into play here? Your logic perhaps can, at a preponderance level, lead to a district court saying, well, there's a known storage location and there's a number of buys, so I can say that there must have been storage on more than one occasion. But if you're arguing there's 2 storage locations, doesn't that kind of fall apart?
That's what we said. If the court had found there were 2 storage locations, the edifice would fall apart. But we didn't. The judge didn't find that those 316 grams applied to Mr. Whitesides. They weren't attributed to him. And so that is not the record we have.
But he also didn't say, well, I don't think he ever stored any drugs there.
So the Snapchats, and when they seized his phone, the text messages and the Facebook say on many occasions, numerous occasions, no number given, that he was dealing out of South 7th Street, the area, then the house, and Spruce Street. And so combine that with the money, we just have lots and lots of transactions, but this enhancement cannot be predicated out of transactions out of Spruce Street. The record simply doesn't support it. it supports storage. And even Mr. Whitesides concedes on page 7 of his reply that storage of drugs for 60 to 90 days is enough to meet the enhancement. And presumably he's talking about the Zamudio case.
Doesn't it also support packaging? I thought that's what Judge Sweeney was getting at, that not only did he store the drugs at his residence, but he packaged the drugs there as well. He also gave his address to drug customers. Usually you only do that if you're going to conduct transactions out of the, I mean, I can't think of another reason why he would have done that under a preponderance standard.
And also Judge Sweeney found that those drug customers were actual drug customers, which we believe he was entitled to find based on the record. But again, the customers have to get the drugs from somewhere. While the record could permit an inference that the drugs were stored elsewhere, that is not the, I would say it's not the best reading of the record, and it's also not what the judge found.
But it would be unusual, the gist of what I got Judge Sweeney to say was it would be unusual to store drugs and packaging material in one place, but remove them to another place for the purpose of packaging.
For the purpose,
It
yes.
was all happening in the residence.
And the packaging is what
That's
you
the
need.
significance of the scales and the baggies and et cetera, et cetera.
Yes. I agree with everything you said, because the packaging is necessary to convert a stored 422 grams of methamphetamine into retail level sales, which you then take elsewhere to make those small transactions.
Maybe you take elsewhere. Maybe you just give your address to drug customers and have them come to your house and pick them up. Which seems to have been going on, I suspect.
To have $14,000 of profit when you don't have a job, and yes, I take Kraft's point about that not being relevant to that case, but without the drug business, there would be no Spruce Street. The rent was paid for with drug money, and without the drug money, there would be no Spruce Street residents to store the drugs. And because storage is central to this drug business, Kraft does not apply on all fours to this case. And if there are no more further questions, I'll end there and thank the court for its time.
Thank you, counsel. Anything further, Mr. Leon?
Thank you, Your Honor. The government says if there's a consistent amount of drug transactions anywhere in Terre Haute and they find drugs in a home, we can assume several months of drug storage. That's not enough. This court said so in Montgomery, it said so in Kraft. If this court takes the government's theory that it can assume several months of storage when officers find drugs in one place, Kraft and Montgomery both come out differently. There's no way to square the government's theory of drug storage with those two cases. Judge Kirsch, you did mention something about there were an ambiguous amount of drug customers receiving the Spruce Street address. Drug customers could be as little as 2. And in Kraft, even 3 transactions that were conceded were not enough. So I don't think we can say that 2 transactions or 2 messages where the Spruce Street address was given for an unknown reason suffices. The government concedes that it can only prove this case on storage, and I asked the court to apply Montgomery and Kraft and rule for Mr. Whitesides. He received several extra years of prison that he wouldn't have gotten if the district court would have applied the law correctly. Thank you.
Thank you, counsel. The case is taken under advisement. Our final case of the morning is Vasquez Rodriguez against Bondi. Mr. Salah.
Yes. Good morning. May it please the court. This case is Mr. Francisco Vasquez, someone who has 3 U.S. citizen children who were ordered removed from the United States based on the court finding that there was no exceptional and extremely unusual hardship to the 3 U.S. citizen children. These children at the time ranged from the age of 6 to 16. They did not, the main issue that they have was that they did not speak, well, with regard to the hardship, the court has, I believe, de novo jurisdiction in this matter because there was error in law. The court did not find, did not follow the main case that resolves exceptional, what is called cancellation of removal. Where one of the points in cancellation of removal would be exceptional and extremely unusual hardship. That's the only issue at stake at this point. The case is Monreal, and in that case, it identifies what needs to be established, and the court and the Board of Immigration Appeals ignored some very important evidence that was presented, and we find that because that whole swath of evidence was ignored, that the review would be a de novo review because it's an error of law. That was the finding in the cases that we cited, which include Iglesias versus Mukasey and the case of Wilkinson. Both of those state that this court has jurisdiction to analyze this case. The main point that we have here is that the evidence was not presented cumulatively. The court looked at the evidence, but at each stage that something related to the children was presented in the judge's final order stated that, I can go through it individually. One of the main issues is that the children do not speak Spanish. We feel that that is a major hardship, exceptional, if children who have never entered Mexico are going to basically a foreign country and would be speaking only English. So the judge ignored an article that was presented, which stated that in Mexico, they do not have courses for English as a second language. The article also mentioned that students are more likely, 3 times more likely to be retained. It also mentions that teachers in Mexico don't generally speak English. There were other matters related to whether the children are able to even study at all, because they their parents come from a small town and there is no high school there. The judge addressed each one of those individually and pretty much minimized the importance of each one of those. And we find that that is not the proper analysis. The proper analysis would be to consider, first of all, ignoring the article, ignoring the country reports was one issue. The other is that it considered each one of those as a separate matter. And if considered collectively with considering the hardships to 3 children, collectively, considering their ages, considering that they've lived in this country all of their lives, considering the hardships that they had, that would be a different analysis. That wouldn't be the same kind of analysis that you would make with each one. When language barrier was brought up, the judge just said, well, they have family members that are there that can help them learn Spanish. When we said that no schools are available, they said, well, you can go somewhere else. How can it be both? When it was mentioned that there are no ability to communicate with anyone else. They said, well, Mexico's a developed country, and they certainly are considering addressing these matters. I think that's a conclusory statement. I think it's debatable that Mexico is a developed country, and it doesn't address their own issues at the moment. Mentioning that Mexico at some point may consider these matters is not what is going to be helpful to these children at this time when the analysis is to be made. There was one other child that had another issue, behavioral issue. She had a substance abuse issue, and that was also considered individually, and the court, as well as the BIA, did not address the
How old
hardship.
are the children? How old are the children now?
It would be 9, and the oldest would be 20. The youngest is 9. The one that has the behavioral or substance issues is a teenager at this time. So I believe that the fact that the court did not look at all of these together in a cumulative manner, even though it's mentioned in passing, but it's minimized. But it's mentioned in passing that, yes, we looked at it collectively or in the aggregate, and that's not enough hardship. But that should require a separate analysis of how 3 children, it's not just one, but 3 children together, the hardships that they will all suffer at the same time, and that would be a greater hardship than if we were talking about one child. And adding to that, the one child that has substance or behavioral issues would aggravate that as well. Again, with regard to that child, and I believe the government is also mentioning it in their brief that there wasn't anything to make this as a serious medical condition, but Monreal says it is not to meet the standard. It does not have to be so restrictive that only a handful of applicants with serious medical conditions are going to qualify for relief. It doesn't have to be to that extent. And the fact that it's stated from, there's a letter from the school, the fact that it states in there that the person needs to see a psychologist is pushed aside, is not considered. It says that that's not enough. Just the fact that a social worker would say that should state that, shows that there is something there. I believe with all of these different conditions and the fact that these matters were completely ignored in the analysis, and the analysis was not done cumulatively, that an error of law occurred, and that the court has jurisdiction and should overrule. If not, then to remand it back to the immigration court. Thank you.
Thank you, Mr. Salah.
Thank you.
Ms. Perlmutter.
Good morning, Your Honors. Alexa Perlmutter on behalf of the Attorney General. The court should deny this petition for review. First, under well-settled case law of this circuit,
Sit down, Mr. Salah.
a notice to appear without the date and time of hearing does not deprive the immigration court of jurisdiction. It does not appear that petitioner continues to press that claim today, so I'll move on to the cancellation application. The agency reasonably denied the application for cancellation of removal because Mr. Vasquez Rodriguez did not show that his qualifying relatives, here his children who will be accompanying him to Mexico, would experience exceptional and extremely unusual hardship. The agency cumulatively weighed the claimed financial, emotional, educational, and psychological hardship factors presented, but given Mr. Vasquez Rodriguez's existing family network in Mexico, extensive work experience, and insufficient evidence that his children would not reasonably be able to obtain counseling and receive an education, found that he did not meet his burden. Mr. Vasquez Rodriguez's assertions now before this court that the agency did not consider evidence of Mexico's educational system and the social worker's letter are without merit. It is clear from the plain text of the immigration judge's decision on administrative record page 76 and 77 that the contents of those documents were not only considered, but accepted as true, but ultimately, in combination with all other factors, did not satisfy the very high hardship threshold set by Congress. And with regard to the children's Spanish-speaking abilities, Mr. Vasquez Rodriguez did testify that the children could speak Spanish to varying degrees and did communicate with their mother in Spanish. Thus, this court should deny this petition for review. Are there any further questions? Thank you.
Anything further, Mr. Salah?
Just wanted to add that the hardship that's required, it states that it can't be, if it's ordinary, then it doesn't meet the burden. We don't believe that this is ordinary, and what the court ruled that it was just ordinary hardship that anybody who would be deported would suffer. That would be just speculative at best. That what is ordinary, we don't know. It was not explained. The court didn't specify what they consider to be ordinary hardship, and that this is just that. I believe that it should be explained. Thanks.
Thank you very much. The case is taken under advisement, and the court will be in recess.